Court is now in session. Please be seated.
All right, please proceed. Mr. Cummings.
Yes.
Good morning.
Good morning, Your Honors. Douglas Cummings, here on behalf of the appellant. That's Hauppauge Digital Inc., the defendant below, sometimes referred to as the company. Before I begin, I'd like to just reserve 7.5 minutes of rebuttal time, and to the extent that the court engages me, it would be my pleasure to cut into that time. In Tiger v. Boast, this court declared that there is no longer a presumption of confidentiality in Section 220 jurisprudence. But in the absence of that presumption, what are the rules governing how that issue is to be litigated or adjudicated? Tiger did not have to go that far because the question wasn't presented. But in the instant appeal, now that question, as a matter of first impression, is ripe. It must be answered not just for the litigants represented here today, but for the advancement of our common law, in which we all take pride in having clear rules. Here we have inconsistent findings by the Master and the Vice Chancellor on the exact same record. We have multiple competing visions of what the rules of litigating confidentiality in a post-Tiger world should be. So within these intellectual disagreements, the appellant perceives a total of 4 legal errors committed by the court below, each of which presenting an independent basis for reversal and remand for findings consistent with the Master's recommendations of 2 years of confidentiality. First error, misinterpretation of Tiger leading to inconsistent rules. The Vice Chancellor placed the entire burden regarding confidentiality on the company and none on the plaintiff. This, His Honor admitted, was a, quote, new approach, close quote. In every other aspect of Section 220 practice and generally in chancery litigation, the burden of proof is on the plaintiff, the party seeking relief. Tiger does not authorize the burden solely on the corporation. Accordingly, the trial court's new approach is inconsistent with Tiger and warrants reversal. Next, the appellee advocates for a burden of proof on both sides. That's a direct quote from the response brief on page 4. This competing concurrent burdens of proof makes for unfamiliar and overcomplicated analyses with apparently the use of 2 scales.
Let me stop you there. As I understand that statement you're referring to, since the court is required to balance the potential harm to the company against the stockholder's interest, why does it not make sense for each side to make their case, in the company's case, what the harm is going to be? They should have the burden. For the stockholder, what the interest is in communication. What's wrong with that test? Why doesn't it work?
Thank you for that question, Your Honor. So this causes us to examine what is a burden of proof. A burden of proof, in my estimation, is a burden of production plus a burden of persuasion. So it's a little bit of, I like to think of it as a triangle, right? A plus B equals C. It's not the Pythagorean theorem, but let's proceed. Anyways, the burden of production says that a party has an obligation to do something, to put forth evidence or testimony. DTLO, either documents, testimony, logic, or otherwise. That's from the Hauppauge decision that I cited in my papers from Vice Chancellor Slights, and that decision was affirmed by this court. Both sides having a burden of production does make sense. In fact, that aligns harmoniously with what was done in Tiger, which was a watershed moment, right? So in the absence of a presumption necessarily requires a burden of production. I'm going to say that again for my own sake. The absence of a presumption necessarily requires a burden of production, right? So unlike the presumption of innocence well, let's look at the presumption of innocence in the criminal context, right?
Aren't we overthinking this?
Oh.
I mean, I think Justice Trainer's question was just a simple, when 2 parties are charged with making their arguments, what does the burden of proof really matter here, except for the fact that the judge hears the 2 sides and then decides whether one side has made the case or not.
Well, I would hasten to underthink this, Your Honor, because the burden of proof should be on the plaintiff. That is the natural course. That is the way of things. Seek and ye shall find. The law favors activity. If a citizen in our community wants relief, they have to prove a right and entitlement to it. That's what the plaintiff is doing. They're asking for publication, public disclosure, right? So we don't want to have the corporation prove a negative. Basically, what we want to do here is look at the plaintiff's proofs while requiring a burden of production. Unlike the criminal defendant, the corporation can't just sit there with its heels up on the desk, fingers intertwined behind its head. We can't have that. They've got to do something. There's an affirmative burden on them. But at the end of the day, it is the plaintiff seeking relief. It is the A plus B equals C that, from the plaintiff's perspective, that we're looking at. And that's...
Well, let me approach it this way. If the court is conducting a balancing inquiry,
Sure.
and it concludes that on balance, the stockholder has made a greater showing of his interest than the company did of the harm, hasn't in effect the burden stayed with the stockholder?
Let me think about that for a moment. Yes, if those proofs rise to whatever standard, the burden of persuasion, whatever that may be. So they work together. It's A plus B equals C, right, Your Honor? So if the burden of persuasion being preponderance of the evidence by credible basis, which is what we are suggesting would be an enlightened pathway forward.
What does that mean? Credible basis in 220 law is typically invoked in investigatory demands. Help me understand, you interject credible basis into a long-standing evidentiary standard of preponderance. How does preponderance of evidence get changed by adding credible basis?
Thank you for that question. I anticipated it. I'm prepared to answer. So first of all, Chancery is familiar with this, as was mentioned by the Chief Justice, in the Hauppauge decision, corporate mismanagement, right? So it's not new, right? So there's that, and with familiarity comes judicial efficiency. It comes the parties being more economical, right? So these are good things. Rule 1 of the Court of Chancery's Civil Procedure Book. We're checking off boxes with this approach. It's great. So you mentioned long-standing. You described this as long-standing. Your Honor, I don't think this is a matter of first impression. There's nothing long-standing here. We are developing, enriching our common law.
Sorry to interrupt, but to clarify, what I meant by long-standing was preponderance of the evidence is a long-standing standard. You have added credible basis to it, and I want to understand how that works.
Thank you. And I want to explain my thoughts, Your Honor. Adding the credible basis is essentially like taking the scales of justice and increasing their sensitivity level. It's like going in and working the inner workings such that we're spraying a lot of WD-40 on it, if you will. So it's highly sensitive. It's actually easier for the plaintiff to make that showing than a pure preponderance standard. So, and that's great. That's great. Good for plaintiffs. Well, Mr. Cummings, are you arguing on behalf of the plaintiff now? I'm not. I'm arguing for an enlightened enrichment and development of our common law. And even applying that standard based on what was proven in the trial court level, I still believe that my client should have prevailed.
What were your two other arguments? You had 4.
Right.
So I thought we'd just done 1 and 2. So do you have...
Two was Southpaw. 2, we haven't touched on Southpaw.
Okay. Sorry, didn't mean to short you 1.
That's all right. That's all right. So, I think our briefs are very, very strong on the Southpaw kind of trail of breadcrumbs, if you will, Your Honor. So I'm not sure how much time I should really dedicate to that. But the bottom line here is that the Court of Chancery made an error in quite frankly, interpreting Tiger. It looked at footnote 17 and said, well, that means that Southpaw is no longer, it's abrogated, it's overruled. And that's just plain incorrect. A careful reading of Tiger says that in footnote 17, talks about the subsequent decision in the Disney litigation. There's two Disney litigation decisions that are in play. The first one has the problematic presumption. The second one has remedies that. And this court looks favorably upon that in footnote 18 of the Tiger decision, right? So what the trial court did, and no one is infallible, is they basically said, hey, I see Disney, I see litigation, there was a presumption there, Southpaw's tied in together with it, so Southpaw must be of no precedential value, and that is not what Tiger says. So Southpaw remains a vibrant piece of our jurisprudence and worthy of precedent. And I can explain why both analytical components that we relied on below help our case and are strong and powerful. But in the interest of time, because of the fact that I've already explained why the trial court erred in a macro sense, I'm not sure if it makes sense to get overly granular there. All right, so if I may, I'd like to proceed to the third and fourth arguments. The third argument is that the trial court erred when it violated the rule of D Jacoby. That's a common law rule arising out of a case opinion from this court. That rule provides that, quote, where exceptions raise a bona fide issue as to dispositive credibility determinations, a new hearing will be inevitable, close quote. At trial, the master's decision seemed to turn, in large part, if not entirely, on the credibility assessment of the company's CFO, F as in Frank. The master specifically found that person's testimony to be both, quote, candid and credible, close quote. On exception and without conducting a new trial, the vice chancellor made credibility determinations to the polar opposite, stating, open quote, nobody thinks the CFO is lying, it's not the least bit implausible testimony, close quote. But then in the opinion, His Honor refers to the company's testimony as, quote, bordered on the hyperbolic, quote, quote, lacked credibility, close quote, and open quote, close quote, sensationalized speculation. So that is the polar opposite here. There are two far ends of the spectrum.
So just enlighten us again how, wasn't this a Zoom recording?
It was.
So he could review it in the first instance as if he was sitting there at trial.
And that is fair, and I saw that to some degree in the subsequent records. But Your Honor, I guess here's how I'd like to approach that. I think we can agree that pure candor and pure hyperbole are inconsistent. If we're looking at the same record, how do we reconcile this? I've been thinking long and hard about this because I have great respect for the Vice Chancellor, and I don't want anything that I've said here today or will say to be anything to the contrary. I think what happened was that the Vice Chancellor wasn't sure what to do. Wasn't sure what there was a lack of clarity of the rules, not because the Tiger is deficient, but because the question wasn't presented before it. How do we do this? How do we litigate? So he found himself thinking about competition, right? And it occurs to me that the Vice Chancellor believes that business equals competition, and therefore there's an unspoken presumption, benefit of a presumption. Is everyone following that train of thought based on my briefing?
Keep going.
Okay. I disagree with that. Competition varies among industries. Let me give you three hypotheticals and then the reality. Number one, a company that has a patent, pharmaceutical company. They're the target of a Section 220 demand. If we are litigating this, will they be able to show competition, as my client did? No, by a matter of law, they cannot. Of course not. They've paid for it. No. Okay, hypothetical number two. New company entering into a new market. Maybe it's got some AI, powered app or something like that. Other competitors are still on the starting gate. They haven't quite lifted off yet. Competition is anticipated. It's tepid, right? Hypothetical number three. If you've walked down Cleveland Avenue in Newark, there are car dealerships, vendors selling cars, all with established brands, right? Competition there is moderate. They can all peacefully coexist. They can all be profitable, right? So there's a spectrum. And then what we presented at trial was intense competition that not all corporations would be able to show, right? We have a financial statement that's got a note from an independent objective auditor that says, hey, if we leave shelf space on another store, we won't have the reserves to survive for another 6 months. Will every corporation be able to show that degree? And it's a matter of degree of competition. I submit to you that answer is no. So I think the Vice Chancellor...
But just to clarify one factual thing, as I understood it, they're seeking only audited financial statements for closed periods, right?
I believe so, Your Honor. But I don't think we should divorce what they're looking for from the confidentiality aspect. It seems mundane, it seems pedestrian. Yeah, sure, okay, closed periods, right? That's what public reporting companies disclose. We are not a public disclosure company. We're dark. SEC permits that, right? So there is no obligation for us to publish, right, in the greater sense, market writ large. I'm going to introduce the fourth error, and then I see my time is depleting. The fourth error is that the court should have never considered publication writ large, that is, to everyone, because it's neither necessary nor essential to Mr. Rivest's stated purpose. As we know, the scope of a stockholder's inspection is limited to those books and records necessary and essential to accomplish the stated purpose. The trial court overlooked the accredited investor definition of the federal regulations. That's a grave error. Why? Because regardless of how you slice it, there is a balancing done. And from my perspective, it's burden of proof on plaintiff, preponderance of the evidence, credible basis, burden of production on the corporation, fine. But no matter how you slice it, that balancing test is adjusted. The weight comes out to a different outcome when you think about the accredited investor definition. Mr. Rivest meets that definition. So, presently, in status quo, without any publication of his financial records, he can trade his shares in the manner in which the SEC envisions. There is no harm. There is no harm to him if there's confidentiality. I'm going to reserve the rest of my time on that point.
Thank you very much.
Good morning, Chief Justice, Justice Valera, Justice Traynor, Marcus Montejo from Prickett, Jones & Elliott on behalf of appellee Mr. Rivest. Justice Valera, just to start, your question regarding whether or not he's seeking just audited financial statements, the answer is no, he's seeking the financial statements as in whatever condition the company creates them in the ordinary course. Which is also under the quotient rule that the SEC has adopted, is exactly what companies are entitled to publish either on their website or on a market maker's website, so that quotes for the stock can be public and trading can continue in the OTC markets.
I think I was asking about whether they were being sought for closed periods only.
Yes, I'm sorry, Justice. It's only closed periods, but it was not limited to audited. So I guess just to back up, the lay of the land before Tiger. Section 220 proceedings would go, and I think Southpaw is actually a good representation of how Section 220 proceedings went in the Delaware Court of Chancery when there's questions about confidentiality, right? The court generally expected the parties to effectively enter into confidentiality agreements that they deemed reasonable, or at least the best that they could negotiate on behalf of their client, and then fight over whether documents produced were actually entitled to be confidential later. And in Southpaw is a good example of that, where the master said, look, I'm gonna deem everything confidential. I'm not determining whether they're actually confidential. I'll make that decision later when I've got a record before me. And as the Vice Chancellor Laster explained in his opinion below, it's that, at least from the perspective of the court, that enabled the summary proceedings to move expeditiously. And you didn't get hung up in the first instance when you're dealing with the company as to whether or not you have to enter into a confidentiality agreement. And the problem from the investor's perspective is that every time you went to the company for even the most basic information, even when the company is public, often the company demanded unreasonable confidentiality requirements. In this instance, this particular company insisted throughout the proceedings that the confidentiality condition would be indefinite. And that's how this issue came up. During the course of the demand on the 220, during the course of trying to get a default judgment against the company, Tiger versus Boast Apparel came out, where this court was clear. Look, there is no presumption of confidentiality. So we've got a company that was entrenched in its position, insisting on a indefinite confidentiality provision for basic financial statements of closed periods that they were unwilling to provide and were not available anywhere else. So at trial, my client proved that this company had a policy of not providing financial information to its stockholders, notwithstanding the fact that 90% of the shares outstanding of this company are held in public markets. So Tiger comes out, no presumption of confidentiality. Instead, what the court should be doing is assessing and weighing the interest of the stockholder against the interest of the company, if any, in maintaining confidentiality of the documents at issue, right? And so that seemed pretty clear. So as we got before the master, the argument was made that, look, the only evidence that was put forth at trial by the company was generic concern of competition. And as far as harm to the company, if the financial statements were disclosed, the company said this would destroy the company. I mean, that's where the sensationalized testimony comes into play that Vice Chancellor Laster was discussing. So Vice Chancellor Laster, I think, appropriately took the interests of the stockholder, particularly in, it's not just an intrinsic valuation that my client should be entitled to, but also testing the market value, and the Court of Chancery took that into account and agreed, and that includes the free exchange of information with other stockholders to discuss the value of the company. And also, because of the quotient rule that had been adopted by the SEC, going to a market maker and getting a quote for the stock. Now, you couldn't go to a market maker to get a quote for a stock unless you had current financial statements. So, and those current financial statements was within a 12-month period for income statements, 16-month period for balance sheet statements. So, in effect, the master's 2-year confidentiality condition precluded a stockholder of a Delaware corporation that was public and traded on the OTC markets from being able to go to a market maker to get a public quote. The court below said that's evidence of harm. That's evidence of harm, and I'm weighing that against the evidence of harm that was presented by the company, which is sensationalized doomsday that I'm not going to give any credibility to. And ultimately, the court, after weighing those interests of both the stockholder and the company, said stockholder has shown a strong interest in receiving these financial statements absent a confidentiality condition. That's it. It's not a complicated case. It's not something that, I mean, this is a court of equity that weighs and balances interests all of the time. So I'm not sure how this becomes a novel issue, but that's where we are today. Unless the court has any questions about the application of Tiger, I'm happy to move on to the other issues that have been raised.
Go ahead.
Thank you, Chief Justice. This Geo Cobb issue, I think the Geo Cobb was such a unique circumstance That case just is not, it really doesn't set precedent at all for any case that I've been involved in before the Court of Chancery, because the Court of Chancery has changed its rules entirely since that case was decided. And this is in our briefs, where the history there is, I mean, you have a master report that had to be created through memory and notes. Memory and notes from the master, because nobody bothered ordering a transcript. Neither of the parties bothered ordering a transcript for the court. That in itself has been fixed down below through the court's rules of procedure. Then you've got the Court of Chancery in reviewing, applying not a de novo review, but basically a deferential review that an appellate court would adopt, reviewing a trial court's findings of fact. And that in itself has been addressed through the Court of Chancery's rules of procedure. Court of Chancery Rule 144 now specifically says that master reports will be reviewed de novo. So, Geo Cobb really presented this unique circumstance where this court actually had to grapple with whether or not there was an unconstitutional delegation of judicial authority by the Court of Chancery to a master in Chancery. So ultimately, because there was no record, this court vacated the Court of Chancery's review, sent it back, and said, you need a better record before we can even tell what you reviewed. Not in those words, but the gist of it. So the Court of Chancery, by that time, both the judge and the master had left the court. You got a new judge, a new master, and you don't get a new master report until 8 years later. The Court of Chancery understood that that's not good. And as Vice Chancellor Laster wrote in his order addressing the limited stay and below, and also as then Chancellor Bouchard had written in McCluskey versus McCluskey, the court has moved past the deficiencies of the record that were created by happenstance in D Geo Cobb. Now, as a matter of course, you have a record that's prepared for any proceeding before the master. Many instances, they're videotaped. This particular proceeding before the master was through Zoom. So it's not like the master was able to sit side by side with the witness. The master was looking through the computer screen just as a reviewing judge would look through the computer screen to observe the demeanor of a witness. So there's a complete record for de novo review in this particular case. And it really gets to the question that I think Chancellor Bouchard mentioned in McCluskey versus McCluskey was, when you've got a complete record like this, whether or not additional proceedings are necessary to assess a credibility issue with the witness, that should really be a question of discretion for the trial court. It's not something that should really be determined by the appellate court in the first instance, right? So again, here we've got a situation where Vice Chancellor Laster had essentially the same record that was observed by the master. There's no question that he could perform a sufficient de novo review, and none of the concerns that were present in D Geo Cobb are present here. So unless the court has any questions or concerns about that particular issue, I'm happy to move on to the last. So the last argument, and I guess I didn't address Southpaw just because I think Southpaw is addressed in the briefs, but it's really, Southpaw, there was no pronouncement of law that, dark companies must be treated as private companies. That's not what Southpaw was about. There was just a statement by the Master in Chancery observing, as a matter of fact, that, the company at issue wasn't publicly reporting. That's it. There was no, assessment that, as a matter of Delaware law, now going forward and forever, we're going to always treat public companies that have gone dark as if they're private. And I don't want to dwell on Southpaw too much, but it does bring up a policy point that I've argued to the master and I've argued to the vice chancellor below. It's that, well, wait a second, Delaware, what compelling interest does Delaware have in keeping financial statements of public companies for closed periods private from the stockholders and from the public markets? This company chose to go public. This company has 90% of its equity held by public markets. And it's a fundamental aspect of Delaware corporate law that public corporations are run for the benefit of its stockholders. So there's really no conceivable public policy to support allowing a company like this one to keep its financial statements private. It's not a private company, as a matter of fact. There's no public policy to allow it to act like a private company. In fact, it encourages the very concerns of the SEC when it comes to frauds and other things that happen in the dark markets. So if anything, there's compelling public policy for Delaware to not allow that to happen. But again, jumping to this last argument that the company is making, and it goes back to this burden of proof. What they're really saying is that they shouldn't have any burden of proof. The plaintiff or the stockholder should be responsible for proving everything. And here they spin Section 220 into an unrecognizable principle by saying that the stockholder must prove that it's necessary and essential for the documents that they receive to not be confidential before they're entitled to receive the documents without a confidentiality restriction. That it's entirely inconsistent with any Delaware case law. The necessary and essential, that has always, in the Section 220 parlance, that has always referred to the scope of documents that you're entitled to. And it becomes, it comes most in play in, investigations of wrongdoing, corporate wrongdoing. Is this necessary and essential to achieve my proper purpose? That's the nature and Sato case. That's what they're talking about. It has nothing to do with confidentiality conditions, which, it's whether or not there's any conditions on a Section 220 inspection, that's discretionary under Section 220 itself. The General Assembly placed that authority within the Court of Chancery. So I just don't know how that necessary and essential concept has been interwoven into the arguments made here on the burden of proof for the plaintiff or for the stockholder in the weighing aspects of Tiger v. Boast Apparel. So for all of those reasons, I think that the Court of Chancery got it exactly right here. The Court of Chancery properly applied Tiger. Court of Chancery properly found Southpaw unpersuasive in establishing the company's need for confidentiality. The Court of Chancery properly determined that it did not need a new trial to assess the credibility of a witness. And also the Court of Chancery properly construed 220 law with respect to necessary and essential, which, by the way, was not even an argument that was presented below. Unless the court has any questions, I'm happy to reserve, or I guess I'm done.
Thank you very much.
Thank you.
Mr. Cummings, you have the last word.
Thank you. I think I have 2 minutes and 38 seconds left. I'll try and be productive and concise. First off, procedural history. I take issue with what my colleague mentioned. The company provided Mr. Rivest from the very beginning, years ago, said, draft an NDA and send it to us, and we'll give you what you want. But Mr. Rivest didn't want that. Mr. Rivest wants to build a public market. That's point one. Point two, an intrinsic valuation serves his purpose. He needs nothing more. Southpaw. Again, I take issue with what my colleague said. Our company is a private company for reporting purposes. And that's authorized under the federal rules. And we have a tension here between, again, state of interests of the state of Delaware and the interests of our federal government. I think we need to, here's an example, and I'm just going to be very blunt here. The accredited investor definition, which was missed by our trial court, this is not what we do every day. We shouldn't be wading into these waters. This should be a federal decision, a federal court decision, not ours, shouldn't be considered in a 220 analysis. It leads to discombobulated results. But Southpaw, two things. We're talking about private versus public. Okay. The private company analogy, which was mentioned in Southpaw, is meaningful to my client in this case and to future cases, perhaps with dark companies, authorized dark companies. They would allow the non-public reporting appellant to be considered akin to a private company for purposes of Section 220 analysis. And this is meaningful because it reflects a determination by management that there is an interest in protecting the business by asserting confidentiality over its books and records. To allow for the contrary would be allowed to have Mr. Rivest make a management level decision. He would be to allow an opportunistic shareholder to make a decision about corporate privacy, contrary to management's beliefs that public disclosure would subject the entire company to substantial harm, is nonsensical and does not respect the Delaware corporate form. The trial court should have permitted the company to make use of the private company analogy from Southpaw. And again, just to repeat, Southpaw remains good law. I see I have very little time left, but I think I've hit on all the points I wanted to make.
Thank you very much, counsel. We
Thank you.
appreciate the arguments. We'll take them out under advisement.
Please rise.